Well, it's a pleasure to be here. I had wished that the original speaker did not have personal problems that needed a substitution, but I am glad to be the pinch hitter and hopefully shed some light on James Madison. Dr. Houlihan had asked me to give an uplifting talk about the Constitution. So I decided to go to the dictionary and look up the word up. Lovers of the English language might enjoy this. Yet it's another example of why people learning English have trouble with the language. Learning the nuances of English make it a difficult language, but then that's probably true for other languages as well. There is a two-letter word in English that perhaps has more meanings than any other two-letter word, and that word is up. It is listed in the dictionary as being used as an adverb, a preposition, an adjective, a noun, or a verb. It is easy to understand up meaning toward the sky, at the top of the list. But when we awaken in the morning, why do we wake up? At a meeting, why does a topic come up? Why do we speak up? Why are officers up for election? And why is it up to the secretary to write up a report? We call up our friends, we use it to brighten up a room, polish up the silver, we warm up the leftovers, and clean up the kitchen. We lock up the house, and some guys fix up old cars. At other times, the word has really special meaning. People stir up trouble. They line up for tickets and work up an appetite and think up of excuses. To be dressed is one thing, but to be dressed up is something special. And this up is confusing. A drain must be opened up, okay, because it is stopped up. We open up a store in the morning, but we close it up at night. We seem to be pretty mixed up about up. To be knowledgeable about the proper uses of up, look to the word up in the dictionary. In a desk-sized dictionary, it takes up about a quarter of a page and can add up to about 30 definitions. If you are up to it, you might try building up a list of the many ways up is used. It will take up a lot of your time, but if you don't give up, you might wind up with 100 or more definitions. When it threatens to rain, we say it is clouding up. When the sun comes out, we say it is clearing up. When it rains, it wets up the earth. But when it does not rain for a while, things dry up. One could go on, but I better wrap up for now, for my time is up. All right? One of the things that I'd like to do when we talk about the Constitution is there are many, many aspects of the Constitution that are quite significant. And James Madison is particularly important. He's the central figure in this drama, and he is an uplifting figure. But let's talk a little bit about James Madison. James Madison was about 5'1", was 110 pounds. He had an annoying, squeaky voice. He was not perceived as either being strong or particularly dynamic. However, this individual had a penchant for knowledge. He could speak Greek, Hebrew, Latin, Italian, and French. Matter of fact, what he used to do for good times was to take the Greek version of the Bible and translate it back to Hebrew. Now, that's probably before cable TV. He had too much time on his hands. But here is a man who read the classics in their original language. In Italian, we often say to translate is to be a traitor. And James Madison believed that knowledge had to be sought at all different levels. Now, he is often called the father of the Constitution. And the reason why he's called the father of the Constitution is that he has achieved many wonderful accomplishments. The first thing is that the Constitutional Convention is initiated to a large degree by his organizational ability. He recruits some of the most important individuals to come to the convention in Philadelphia. The single most important recruit is George Washington. Now, George Washington didn't say very much. He didn't act very much, but his mere presence gave authority to the Constitutional Convention. Let's get silly here. There were probably more people named George in 1787 than any other name. And that's attributable to the respect and authority that George Washington had. He was American Cincinnatus. He was at his plantation. He had a call to arms. He served in the Revolutionary War for over 8 years without pay. He risked his life, he risked his fortune, and at the end of the day, he went back home to Mount Vernon. He was then summoned reluctantly. And of course, this tells us a great deal about leadership. It tells us a great deal about authority. And it also tells us that George Washington gave more authority to the Constitutional Convention than anybody there. And Madison's coup of recruiting him, and recruiting people like Ben Franklin and Edmund Randolph and James Wilson, he created a collection of talent that if they weren't there, the Constitutional Convention would never have resonated with large numbers of people. But he did more than that. And of course, I hope he did, because we have another 50 minutes to go. What he did was to create a strategy. And that strategy was to come to the convention with a plan. We call it the Virginia Plan. But more importantly, what Madison saw was the opportunity to deal with what he perceived as the weaknesses of the Articles of Confederation. The Articles of Confederation, for many, many people, were nothing more than a military alliance. But what was going on in the country at the time was high inflation, high debt, there was threats, military threats, and the possibility of fragmentation. What he wanted in the Constitution was a government that could provide, certainly for national defense, but clearly he wanted other things as well, to regulate commerce, to have a stable currency, the ability to tax, which was essential for stability. And his Virginia Plan was radical. The Virginia Plan, in effect, called for a Congress to have all legislative powers. Not some powers, but all powers. It would be the equivalent of the British House of Commons. The British House of Commons, of course, has no limits. And one could argue that they could actually pass a resolution to change girls into boys or boys into girls. Now, the likelihood is that they won't do that, but there are no limitations. At least that's the point. During World War II, Winston Churchill was able to create a cabinet, basically where he was the principal member of the cabinet. As it's often said, when he went to the water cabinet, he could have a cabinet meeting. All right, but that's neither here nor there. American presidents, whether it's Abraham Lincoln during the Civil War, Franklin Roosevelt during World War II, had to undergo elections because the Constitution is fixed. It doesn't allow for that kind of flexibility. So when we talk about the Constitution, we have to understand what Madison was hoping to achieve. What he had to do was break the logjam. What he had to do was not to make the powers to tax, to regulate commerce, to issue currency, to seem radical. He, in effect, compromised back. And by compromising back, he was viewed as someone who was conciliatory, someone who had an idea, and someone who would be clearly accepting of a much more powerful government, but far less than he initially called for. When we see the architect of James Madison, we recognize that here is a man who does enormous number of things. And what are his bottom line, if we could use that expression? And I would say that there are three basic principles that James Madison believed in dearly, and these were not subject to compromise. The first one was natural law. He was a devout follower of John Locke. He believed in life, liberty, and property, or as Jefferson transmuted those terms, to the pursuit of happiness. He believed that man was born with genius, that man did not need government. Government was a tool of man. Government was not the instrument to take care of man, because that would deny man's humanity. In effect, he believed strongly that the government that governs least governs best. But he's not an anarchist. He believes that there has to be a balance. And when he creates the Constitution, there is the preamble, which I think is a rather significant point, and separates the American experience from the experience of other democratic and liberal societies. We begin the preamble with "we the people," and the source of all government power comes from the people. This is radically different from the Magna Carta, where the barons and the lords petition the king, King John, and beg him for rights. The rights do not belong to the sovereign. The rights belong to the people, and the people are the sovereign. Now, this may sound more rhetorical, but philosophically, people are born with rights. This is a core principle of John Locke, of Thomas Jefferson, and of course, James Madison. Madison believes that a constitution must also be created that doesn't just talk about rights, but creates an institutional arrangement that prevents rights from being abused. And for this, we have to look at two basic principles of governance. The first one, natural law, is a philosophical. The other two are operational. And I would name them as separation of powers and as federalism. Now, when we talk about separation of powers, clearly this is a concept that goes back to antiquity. Aristotle spoke about separation of powers, but more contemporary to the time is Charles de Montesquieu, who wrote The Spirit of the Law. And Montesquieu had an interesting expression, what I think I would like to share with you. He says, we often mourn people at their death. He says, we should mourn people at their birth. Wow. What he's suggesting is a penchant for evil, a penchant for bedeviling behavior. In other words, a selfishness, perhaps, and an incorrigibility. In essence, what Madison learns from Montesquieu is the understanding that rights written on paper are not worth the paper that they're written on. That what you need is to prevent power from actually existing. Certainly, power is necessary, but too much power is not necessary. Let me go to Federalist 51, because Federalist 51 and Federalist Number 10 are two of the most interesting essays that were written by any American. And let me just read a little bit from it. It's not very long, but people like Clinton Rossiter would say that the Federalist Papers were the greatest work done by political scientists in American history. Of course, Clinton Rossiter didn't read my works, but that's another story. Okay. But the great security against the gradual concentration of the several powers in the same departments consists in giving those who administer each department the necessary constitutional means and personal motives to resist encroachments on the other. Ambition must be made to counteract ambition. The interest of man must be connected with the constitutional rights of the place. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest reflection on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In effect, What the suggestion here is that individual rights could only exist if there isn't passion in government that is able to implement its will. James McGregor Burns, another political scientist from Brooklyn, wrote a book on leadership, and that's perhaps his most famous book. But an earlier book that he wrote was called The Deadlock of Democracy. And in effect, the separation of powers, by concentrating powers over three separate institutions, made frustration, made for deadlock. And deadlock is often something that many people feel terrible about, that we can't get an agenda through. But for Montesquieu, for Madison, and even for James McGregor Burns, what happens is that when there is deadlock, the responsibility for individual accountability, individual achievement rests with you and not with the government. In addition, abuse of rights could only take place when an institution has the capacity to coerce. Consequently, when we look at Madison, Madison believes the enemy is government. And the reason why he sees the enemy as government is because it has the possibility of imposing exploitation, imposing an abuse of power and abuse of rights. No other institution can do that. Now, many people would argue that the period of 1787 is very different from 2011. And that's certainly true. But to understand the Constitution, one should understand that what Madison tried to create was not an institution that wrote down rights, but an institution that was incapable of taking rights away. And that is a philosophy that many people would say has created the American Constitution as the longest lasting continuous republic in the world today. For all of its flaws, one has to argue its successes as well. All the things we desire that we do not receive because of separation of powers is also, we have to count the blessings for the things that were not done. Clearly, what Madison has tried to create here is frustration. What he's trying to create are circuit breakers. I often use this expression a great deal, but when I drive on the FDR, there's usually too much traffic, and there's usually some very bad drivers. And sometimes they occasionally cut me off. And then I then do something stupid or crazy. I drive to meet that individual and perhaps even give them some hand signals. What I realize 10 minutes later is that I've jeopardized myself. I've jeopardized other people in the car. I've jeopardized fellow drivers. What I needed was a circuit breaker. Right? If anything doesn't matter 10 minutes later or a half hour later, in my case, 2 years later, all right? What happens here is that the separation of powers creates an opportunity for delay, for emotions to subside, for reason to prevail. What the separation of powers also does is allow individuals, minorities, to create the capacity to stop the will of government. Now, the third principle that we talk about is federalism. And federalism is a very complicated concept because there are so many different implications to federalism. But let me focus on Federalist Number 10, because Federalist Number 10, in some people's judgment, is the premier Federalist paper and the single most significant writing when it comes to the passage of the Constitution. After all, the principal argument against the Constitution was too much power in the central government. Let me read Madison. Among the numerous advantages promised by a well-constructed union, none deserves to be more accurately developed than its tendency to break and control the violence of faction. What we must recognize is democracies historically destroy themselves. And as a consequence, the promise of democracy is met with the consequence of violence. However anxiously we may wish that the complaints had no foundation of evidence, of known facts, will not permit us to deny this some degree to be true. By faction, I understand a number of citizens, whether amounting to a majority or minority of the whole, who are united and actuated by some common impulse or passion or of interest adverse to the rights of citizens or to permanent aggregate interests of the community. There are two methods for curing the mischief of faction, one by removing the causes, the other by controlling its effects. There are again two methods for removing the causes of faction, one by destroying liberty, which is essential to its existence, and the other by giving every citizen the same opinions, the same passions, and the same interest. It could never be more truly said that the first remedy, that it is worse than disease. Liberty is to faction what air is to fire, an ailment without which it instantly expires. But it could be less folly to abolish liberty, which is essential to political life, because it nourishes faction, than it would be to wish the annihilation of air, which is the essential to animal life, because it imparts fire its destructive capacities. Liberty creates its own problems. But what are we to do? Eliminate liberty? Give everybody the same positions and passions? If we eliminate liberty, we've solved the problem. But the problem that we create is worse. Because ultimately, that natural rights belief that individuals become human by the pursuit of their passions, and that requires liberty. Let's go further. The second expedient is as impractical as the first would be unwise. As long as the reason of man continues fallible and he is at liberty to exercise it, different opinions will be formed. As long as the connection subsists between his reason and his self-love, his opinions and his passions will have a reciprocal influence on each other, and the former will be objects to which the latter will attach themselves. We love ourselves. We believe we're right. I believe what I believe because I believe it. Not because I think I'm wrong, but because I think I'm right. And usually those things that I believe in also have the capacity to advance my sense of virtue, my sense of justice, or my sense of economic gain. So what is being suggested by Madison is that liberty will lead to faction, or as today we would say, interest groups. Now the problem that emerges is that in a small republic, factions often become majorities. And majorities are the greatest threat to liberty. Let me use Montesquieu once again because I think Montesquieu is illustrative in this point. Those who have power have an obligation to abuse it. That's a fascinating expression. What he's suggesting is if I think I'm right, then I must pursue it with all my power, with all my passions. And I must not compromise. What stops me from being successful is the lack of power. But in a small republic, like-minded people might all agree, or at least a majority. And then those who disagree would be at the loss of liberty. So what Madison does here is he says, I believe in liberty. I believe in democracy. But small republics are dangerous to themselves. Let's go a little bit further in Federalist Number 10. He says, no man is allowed to be a judge in his own cause, because his interests would certainly bias his judgment and not improbably corrupt his integrity. with equal, nay, with greater reason, a body of men are unfit to be judges and parties at the same time. Yet what are many of the most important acts of legislation, but so many judicial determinations, not indeed concerning the rights of a single person, but concerning the rights of large bodies and citizens? And what are the different classes of legislators, but advocates and parties to the causes which they determine? Is a law proposed concerning private debt? Is a question to which creditors are party on one side and debtors on the other? Justice ought to hold the balance between them. In other words, what Madison is suggesting here is most legislation will benefit one group or another group. But if one group is in the majority, they will pursue with passion, with dedication, with ruthlessness their position. So what he's suggesting is no one be a majority. And the only way that can happen is if you extend the republic. Let's go to exactly what he says here. The other point of difference is the greater number of citizens and the extent of the territory which may be brought within the compass of Republican and Democratic government, and its circumstances principally which render fatuous combinations less to be dreaded. Extend the sphere, and you take in a greater variety of parties and interests. You make it less probable that a majority of the whole will have common motive to invade the rights of other citizens. Or in such common motive exists, it will be difficult for all who feel to discover their own strength and to act in unison with each other. If I represent a minority of opinion, right, then for me to succeed, I have to persuade a group of people who are in the middle, people who are indifferent, who aren't affected by the benefits or the disadvantages of that decision. In effect, it makes me humble. It makes me want to protect other people's rights, because if I am a minority, I may in turn be the subject of abuse of rights. Let me go further, because James Madison followed Niccolo Machiavelli. And Machiavelli is famous for saying, there are no permanent allies, there are no permanent enemies, there are only permanent interests. And what Machiavelli was attempting to say here is that what I need to do is I need to protect myself, and I may need you in the future. And if I need you in the future, I don't want to destroy you in the here and now. So what this particular Federalist Number 10 is saying is that the larger the republic, the more we all become minorities. And once we become minorities, we can no longer be arrogant. We can no longer be exploitative. Now, let me reflect on that a bit. Clearly, Madison knows that separation of powers and federalism, while going a long way, will never eliminate abuse and exploitation. But his argument is a pragmatic argument. Have we moved further along where the instances of abuse are greatly reduced? The instances of the loss of rights greatly reduced. And clearly, what Madison is hoping for is an operational system which protects and promotes individual liberty. Now, there are some important aspects that also need to be explored here. Clearly, one of the things that Madison was concerned about was how the Constitution would not only be extended through federalism and not only have a separation of powers, but how do you deal with the mechanics? And the first thing that we have to deal with is the Bill of Rights. And when the Constitution was being debated, there were no Bill of Rights. And the discussion that emerges was that Madison becomes quite defensive. He says, we don't need a Bill of Rights. And the reason why we don't need a Bill of Rights is because the Constitution has enumerated powers. And the word Constitution means to limit. So the national government only has the powers that are granted to it. Therefore, if you are protecting against things that the national government doesn't have power, you are asking for someone else to give you permission. Clearly, what he is suggesting is the Bill of Rights is unnecessary. But he goes beyond that. He says the Bill of Rights is actually dangerous because you could never list all of the rights. The right to have a child, the right to marry, the right to own a car, although they didn't have cars then, right? Or a horse, all right? The right to travel. So what emerges is the pragmatist in Madison. He decides that the Constitution is going down because this argument is resonating. And if this argument is to continue to resonate, then he has to make a choice. Faustian choice, perhaps, but the choice between the Constitution becoming more imperfect with a Bill of Rights or no Constitution at all. So he promises, right, to write the Bill of Rights. So he's not only the author of the Constitution, the author of the Federalist Papers, but he's also the author of the Bill of Rights. But what he does is he writes the Ninth Amendment. And the Ninth Amendment simply states that all rights not enumerated should not be construed as not existing. In effect, just because it's not stated doesn't mean it's not there. And of course, I like to say that the Ninth Amendment is Madison's revenge, because we've been trying to define what that means ever since. Is there a right to privacy? Is there a right to abortion? Is there a right to any of the things that we sometimes suggest? But there's more. Madison viewed the Constitution as something that needed to be venerated. And here's where he departs from Jefferson. Jefferson believed that each generation should write their own Constitution. He believed that the Constitution should be clear, should be enact, that every generation who reads it would know what it means. And this creates some problems. Some people call him a strict constructionist. And we could use that term, but it's a term that is more imposed from contemporary debate. We would argue he was a literalist, because when you use strict constructionist, what you're basically saying is, what was the intent of the framer? He's the framer! He knows what he meant. So there's a little point here, just a bit of humor, I guess, but maybe not that much. All right, the key element here was, what should the Constitution mean? And people like Alexander Hamilton were in favor of what we call a loose construction. And the preamble of the Constitution talks about the general welfare. And this drove Madison crazy. Because one, the preamble, strictly speaking, is not part of the Constitution. Secondly, if you're going to say general welfare, it means that the Constitution, you can do anything you want, anytime you want, because you have a majority. And what would be the purpose of writing a Constitution if you're going to base everything on the preamble? By the way, the same preamble, almost word for word, was part of the Articles of Confederation, and nobody believed that the general welfare phrase gave the Articles of Confederation or the national government those kinds of powers. But there were other aspects as well here. Madison believed, and perhaps this is the most significant disagreement in his time period, what we would call the theory of implied powers. Theory of implied powers is mostly based on Article 1, Section 8, Paragraph 18, what we call the necessary and proper clause. And the necessary and proper clause, according to Hamilton, basically became necessary and convenient. If something were convenient, we could do it. In other words, if we had to collect taxes, if we had to pay debt, if we had to issue currency, a bank might provide the necessary capacities to do so. It might provide desirable capacities. But Madison said the word necessity means without which something couldn't be accomplished. And therefore, he was opposed to this theory of implied powers. In the famous case McCullough versus Maryland, we have John Marshall interpreting those words from Madison and basically turning them around, saying any means necessary. You could imagine Madison's anguish that the words he writes are being interpreted by someone else who's telling him what he meant when he's still alive during this process. But this becomes an important point. Charles Evan Hughes once said, "We live under a constitution, but the Constitution is what the judges say it is." Woodrow Wilson, when he wrote Congressional Government, not when he was president, said that the Supreme Court was a constitutional convention in constant session. Now, whether one agrees with the desirability of those two quotes, Madison believed that they were destructive of what a constitution ought to be. And therefore, he rejects these notions. Because if the Constitution could be meant to be anything that a judge decides it to be, that we can use contemporary standards rather than just principles, he believed that if you need to change it, you change it by the amendment process. If you need to change it radically, then you call for another constitutional convention. But don't bastardize the words. Don't manipulate. Because then you lose the veneration. You lose the devotion. Let's go to perhaps the single most important issue of his time. And this is the instance of judicial review. Today, almost everyone accepts the concept that judges, particularly the Supreme Court, has the right to declare actions of the legislature, actions of the executive unconstitutional. But Madison wrote the words, right? He wrote the words. And in the case of John Adams, what we sometimes call the midnight appointments, but we have a situation where after he's defeated by Thomas Jefferson, there is appointment of large numbers of individuals to the federal judiciary. Now, Marbury is at a very low level. All right, he's Justice of the Peace. He's nominated. He was nominated by the President, confirmed by the Senate, and commissions were actually prepared. Right? Thomas Jefferson becomes president, and Jefferson does not want in any manner, shape, or form these former Federalists to receive patronage for a good part of their lives. So Jefferson, according to many reports, actually takes these commissions and throws them away. Now, whether that is actually true or not is really subject to some debate. But what we do know is that Marbury sues, all right? And when the court is being brought to its hearing, John Marshall, who was the former Secretary of State, the individual who wrote the commissions and had the responsibility to deliver those commissions to Marbury et al., was too busy, right? He was becoming Chief Justice of the Supreme Court. By all stretches of today's standards, he should have recused himself from those decisions. But what does Marshall do? Marshall says that the Federal Judiciary Act of 1789, which, by the way, James Madison writes, right? Another one of his contributions, which basically says that the Supreme Court can be granted additional original jurisdiction. In other words, the right to hear a case initially. Right? Marshall argues that the Federal Judiciary Act of 1789 is unconstitutional. Not the whole thing, but that particular part of it. Now, John Marshall is arguing now with the new Secretary of State, James Madison, the man who wrote Article 3, the man who wrote the Federal Judiciary Act of 1789. And when you read Article 3, at the end it says, with such exceptions and under such regulations as Congress may ordain. Most people would argue that if Congress said we could add to the original jurisdiction of the Supreme Court, that's at least a reasonable argument. But what's the point here? James Madison, the author of the Constitution, the author of the Bill of Rights, the author of the Federal Judiciary Act, loses. Right? So while it is James Madison's Constitution, right? It's James Madison's Constitution in terms of its initiation, but once beyond Madison's control, he loses on the Bill of Rights. He loses on the theory of implied powers. He loses on judicial review, which, by the way, he considered an abomination of democracy. Right? How could you have 9, or in that case, 5 and 6 judges overturn a majority of your legislature? But later on, we see even more aberrations. During the Civil War, Abraham Lincoln, one of the great presidents in most people's judgment, undertakes a notion that the words commander-in-chief give the president the opportunity to suspend the writ of habeas corpus, to blockade ports, and to spend money without the authorization of Congress. And let's add insult to injury. Instead of the Constitution, Abraham Lincoln is devoted to the Declaration of Independence, which he considers the mission statement of the United States. Madison argued that those individuals who conduct war should not be the individuals who decide whether war should exist or not exist. They should not determine the amount of money, and they should not determine when war ends. In effect, Abraham Lincoln, right, gives the final blow to Madison's vision. And let's go a little further on this. The Constitution does allow for the suspension of the writ of habeas corpus, but that is in Article 1. Lincoln argues that that was a mistake. It should have been in Article 1. Poppycock, right? Madison knew exactly what he wanted to do. He wanted to protect the nation from executives who he believed were more likely to engage in war. We could see the further erosions of James Madison's Constitution. But let's see what his legacy really is. The legacy of federalism, the legacy of separation of powers, checks and balances, deadlock of democracy, has essentially served the nation well. People like George Wills said, if the pen is mightier than the sword, Washington, D.C. should really be Madison, D.C. When we look at people like Ron Chernow, historian, they would argue that no one, in terms of writing the Constitution, defending the Constitution, being the principal architect of liberty and individual rights, has ever done it better. And that includes Jefferson, Adams, Franklin, and Washington. Mr. Madison, the man who we could still attribute most of the principles, most of the dynamics of American society, He didn't win all the battles, but no one does. Thank you. Anybody have any questions? Very interesting. People like Patrick Henry, all right? Samuel Adams, the patriot, not the beer. These were individuals who believed strongly that they were up to no good, and that ultimately the Constitution was a betrayal of the Revolutionary War. Now, Patrick Henry and James Madison were rivals. Patrick Henry was a great orator. He was tall, he was articulate, he was forceful, and you got the squeaky little James Madison. When they had the convention in Virginia to the ratification of the Constitution, Patrick Henry gerrymandered, all right, so that it would be very, very difficult for Madison to even be part of that convention. So there are individuals who they believed would have been counterproductive. Now, clearly, people even like Thomas Paine believed that the power that is gravitating to the central government would inevitably lead to a colossus, a monstrosity, an albatross, if you will. All right? But for Madison would argue that the disintegration after things like the Shays' Rebellion, the notion of the panics, the notions of the civil unrest, the notion of the possibility of foreign takeovers. The French and the British continued to have designs. He thought it was the kind of compromise that could morally be made. But Patrick Henry, Samuel Adams, Thomas Paine were not invited. Excellent question. And it's basically resolved in McCullough versus Maryland, where John Marshall makes an argument, and you might consider it demagoguery, but I think it's an interesting argument. He looks at what we sometimes call the exegesis of the 10th Amendment. And if you go back to the Articles of Confederation, there's very similar language, all right? So in the Articles of Confederation, it says, all powers not specifically delegated to the national government nor denied to the states or reserved to the states and the people. So that word specifically is not there in the 10th Amendment. And so the argument comes, was it a mistake? And John Marshall goes to the debates over the 10th Amendment. And there were 3 occasions where the word specifically was to be inserted as an amendment. And on 3 occasions, it was rejected. So Marshall comes up with the conclusion that they didn't want it there. They didn't want that word there. And therefore, all powers not delegated essentially means that what the Congress determines, which is delegated or not delegated, because it includes enumerated and implied. Now, many people believe that McCullough versus Maryland is in many ways the beginnings of the Civil War, the beginnings of the belief that states' rights are going to be severely limited, and that the Supreme Court would be the instrument to define exactly where national powers end and state powers begin. What would stop the Supreme Court from saying slavery, all right, was unconstitutional? What would stop the Supreme Court from saying export taxes can be imposed? So in effect, it's not only McCullough versus Maryland, but the theory of implied powers opens up what we sometimes call the Pandora's box, all right? There is so much debate about are there any limits? And of course, we didn't even get to the Commerce Clause, which is something that is extremely complex in Madison's understanding. But clearly, the theory of implied powers and judicial review are the 2 great failures of Madison. And they're failures not of philosophy, they're failures of politics. Right? He loses. Yes. New York State was critical. It was not the largest state in the Union, but it was the commercially most important state. And the belief was that if New York State decided not to ratify the Constitution, then the rest of New England would also follow. And you would then create a separate nation on the North American continent. So New York State was particularly important. Keep in mind that during the Revolutionary War, New York State had enormous loyalist support, maybe more loyalist support than any other state in the Union. One could even argue during the Civil War that New York State was the most loyal to the Confederacy. All right? New York State is the aberration, right? Clearly, it was not in line. And Madison, Hamilton, and Jay both understood that New York State was critical. But it's not only New York State. Virginia was also critical. Pennsylvania was critical. Delaware, not so much. All right? It's nice we got Delaware. But Virginia, and New York, and Pennsylvania were clearly the most important states. People would say that Madison is a failure as president. All right? Certainly the War of 1812 was a disaster. And many people say he was too intellectual to be president. He saw all sides. Matter of fact, he saw more sides than there were. And that was a problem. He wasn't inspiring. And as a result of the War of 1812, one of the things that emerges, and I think emerges quite interesting, is the evolution in Madison's thinking. He was suspicious of a large standing army, and during the War of 1812, he realizes the benefits of a large standing army. He is hesitant about a bank, all right, but then he sees the wisdom of having a bank. In effect, many people see Madison as wishy-washy in his presidency. But the most important problem with his presidency is that in many ways he detracts from some of the arguments that he made prior to his presidency. And therefore his legacy is left mixed. What did Madison really believe? All right? And of course we could say that even intellectuals learn, which is a big question mark, but that here is a man who was tempered by the realities of the War of 1812. And let's face it, the British won the War of 1812. Right? Andrew Jackson in the Battle of New Orleans is fought after the Treaty of Ghent. And the net result, of course, is pride that emerges. But the War of 1812, often called the Second War of Independence, is a colossal failure. The White House is burned, people fleeing. The notion that the American system of government was shattered. And in effect, it was his call. So if one looks at that, I would say that his presidency probably was not the shining moment of his career. However, when we look at Madison and his presidency, I think it's important to note that here is a man who, at 36, wrote the Constitution of the United States. At 38, wrote the Bill of Rights, right, and the Federal Judiciary Act. By the time he became president, this was insignificant almost, right? Most presidents have nowhere near the influence that Madison had. So his legacy is enduring, even though his presidency is perceived with mixed reviews. I might argue that John Marshall, appointed by John Adams in the final days of his presidency, afterwards had much more influence than Madison. And of course, they disagreed on everything, including the alphabet. All right. Well, there was an interesting story, and a lot of this stuff is a form of mythology. But New York State had deadlock within its own legislature. So during the Constitutional Convention, it was unclear what the direction of the state legislature ought to be. Now, Hamilton was not an individual who was in favor of following protocols. So he did what he wanted to do. But technically, Hamilton was operating without clear instructions from the state legislature. So that's why he becomes a signer. I may want to add one other thing about Hamilton, because Hamilton also is a great influencer in the constitutional system. One of the things that he did was he wanted to have a king imported from Europe, and that king would serve for life. And this was so offensive to Madison, all right? And then when Hamilton becomes Secretary of the Treasury, there is a view, there's a deep, deep suspicion that Madison has. And then when Madison starts articulating things like the bank and deciding that the national government can do essentially whatever it wants through the Commerce Clause, Madison is pulled much more into the orbit of Jefferson, right? Jefferson and Madison were not the same. They disagreed on a number of things. But after Hamilton, they realized that the joint operation was absolutely necessary to prevent the sons of bitches from gaining control.
Okay. And on that note, let's thank Dr. Sorrentino for a wonderful.
Thank you. Thank you.